Dramani Mahama announces raft of measures to tackle the increasing cases of fire outbreaks in markets.
Energy Minister Designate reiterates government's resolve to privatize the Electricity Company of Ghana within the next 6 months.
And also, Operation Recover or Loot team tours state lands and properties earmarked for redevelopment by private developers or sold to government officials.
Coming up in business news, President John Mahama assures independent power producers of his government's commitment to resolve the country's power crisis.
Elsewhere around the world, at least 16 civilians in Nigeria's northwestern Zamfara state have been killed in a military airstrike after being mistaken for criminal gangs. So this is News 360 live from our studio here at Designate, and I know that many of you have been following the proceedings of the vetting committee, which is currently ongoing in Parliament. So we don't want to frustrate you or break your interest. We're crossing back to Parliament to consider with the vetting of the Attorney General Designate, Mr. Ayine, Dominic Ayine, Doctor.
The letter of termination does not, or is not mindful of the financial liability that will accrue to the Republic as a result of his or her conduct. I think that we should begin to also punish, such people when they, misconduct themselves. That is all that I'll say for now. So when they know the legal consequences will be adverse, they will be careful not to arbitrarily terminate and then bring about judgment debt.
Thank you very much. Any further questions?
Thank you very much. What would you do in your capacity as an Attorney General to continue the tradition of a zealous defense of the state's interest in international arbitrations? What specifically will you do? Yeah.
Thank you. Any answer to the question?
Well, we definitely will be putting our best foot forward by getting lawyers, either local or international, that are knowledgeable, that are skillful, and that have integrity to represent the Republic and defend its interests, before these arbitral tribunals.
Thank you very much. Thank you. It's now the turn of the minority.
Professor Ayine, congratulations. Your academic credentials and prowess is well known, but I know you as a man of fashion. And I've always admired you for that. And I'm sure that as Attorney General, I don't know whether your fashion will change, but congratulations. But I have one important question for you. Ghana ranks 72 out of 180 countries in the 2023 Corruption Perception Index, indicating persistent challenges with the issue of corruption. What innovative and practical measures will you champion to strengthen the capacity of anti-corruption institutions in the country?
Thank you for your question. Any answer?
Thank you very much, Honorable Chairman. Just to let the nominee know that my fashion taste will not change as Attorney General. The Honorable Member, I'm so tired. I'm reversing the cut. Yes. When it comes to the issue of corruption, as a country, we've tried various mechanisms. We've tried various institutional measures. We formed commissions of inquiry. If you go back to our history, the Olenu commission of inquiry was into the sale of import licenses and the bribery associated, therewith at the Ministry of Trade. For the lawyers around the table, you remember the case of Kenya versus the Republic. That case, arose out of the Olenu Commission of Inquiry report. So using commissions of inquiry have been, has been one of the things that we've used to fight corruption. Of course, constitutionally, you remember that SRAJ is also another institution that has an anti-corruption mandate. And at the beginning of the Fourth Republic, you remember very, very well the work that its first chairman, Emil Schott, did with, high public officials appearing before the SRAJ. Some of it went to the Supreme Court in challenges, and there are decided cases dealing with the procedures that were adopted and so on. We've had, various other bodies that we've used and institutional measures that we've used to fight corruption. So, Mr. Chairman, there is no shortage of institutional measures, all right? When you set up institutions or you create institutions, and by the way, institutions are the rules of the game in the society. So, the norms, the practices, the hardcore statutes and so on are all, institutions. So there's no shortage of institutions in this country. But sometimes implementing the measures is where the problem is. So I'm going to give you one example. So we have the Whistleblowers Act, right? The Whistleblowers Act is supposed to, give whistleblowers who may be near the action as far as corruption, bribery and corruption is concerned, to provide the requisite information to law enforcement agencies to take action. Okay, and when I was Deputy Attorney General, we had situations where a whistleblower, gave us information, and then we did the investigation, and eventually we recovered over $30 million, 30 million Ghana cedis. That is the record that is not being talked about. We recovered over 30 million Ghana cedis, which was, which was paid by those who were involved. But because of confidentiality reasons, I cannot mention those, who was involved. So, for instance, the plan, which I have discussed informally with His Excellency, is for us to have a whistleblower agency in every district. And then to publicize the procedures, create a hotline where if there is wrongdoing that is happening, okay, we will, that hotline can it can be the regional chief, the chief state attorney, being called and, a report being made so that he can then, with the police and the other investigative bodies, investigate and then, ensure that the wrongdoing which is being reported, the evidence of it is gathered and so on. So in every district, we'll implement it and then have a hotline that can be used to report, information about corruption. So the anti-corruption institutions, okay, should not be thin on the ground or centered in Accra and, depriving ordinary people of the opportunity to report, acts of corruption. And of course, under the Whistleblowers Act, when you report and there's a recovery, you are entitled to 10%, a percentage. And I remember that in this case that I've cited, the whistleblower was actually paid. The Honorable Atachia, eventually, if you want to, cross-check what I'm saying, you can ask him. The Honorable Atachia represented the whistleblower in his pursuit of the 10%. We agreed to pay when MPP took over. There was some hanky-panky, and then the whistleblower had to go to court. So that is an incentive, for whistleblowers to report. So, Mr. Chairman, we need to operationalize and make sure that the anti-corruption institutions, the anti-corruption measures permeate all the way to the local level. That, you know, during the revolution, of course, there were excesses, but during the revolution, the Honorable Cletus Avoka is here. Those days when we were young men in Bolga, they were the revolutionary lawyers. And of course, the reports, they caught many people, civil servants, public servants, engaged in bribery and embezzlement. And they were tried by the tribunals and in some cases by the courts. In some cases, they were sacked. I think that those radical measures need to be reintroduced. Thank you, Mr. Chairman.
Chairman, no further questions. Congratulations.
Thank you very much. It's now the turn of Honorable Minority Leader.
Council, congratulations.
Thank you, Mr. Chairman.
Chair, I want to take my respected colleague and learned colleague to his CV, page 1. The page 1 of your CV has no biodata of you, so can you graciously provide us with your biodata?
Okay, so for the record, my name is Dominic Akunritinga Ayene, and I was born on the 6th of January, 1966. To Mr. Ayene Atenga and Madam Ateni.
What's your address, please? Your residential address?
My residential address is number 3 Kofi Annan Avenue, North Legon, Accra.
Your postal address?
P.O. Box LG 70, Legon, Accra. I still use my address, the address that I was using when I was a lecturer. It's allowed because I'm still associated with the University of Ghana.
Now, have you paid all your taxes to date, or have you made an arrangement to meet those obligations to the state?
Mr. Chairman, actually I have a credit of 470 cedis that the Republic owes me. In other words, I've overpaid. On my tax, clearance certificate, which I can present to the committee.
Do you immediately remember how much tax you paid to the state last year, for which you have gained this credit?
No, please.
If given the opportunity, would you be able to furnish this committee with the amount of tax you paid to the state in the year 2024?
Yes, Mr. Chairman. I can furnish the committee with all my tax record, including those from my law firm. I'm very, very, very up to date with my taxes. I don't joke with it at all.
Chair, I'm very specific in my dealings with my respected colleague. I'm asking about your 2024. I'm not talking about other matters.
Yes, yes,
2024.
Yes, Mr. Chairman.
Very well. Chair, may I know from the nominee whether he ever represented Fidelity Bank as its external solicitor?
Yes, Mr. Chairman, I've represented, and in fact, I'm still representing Fidelity Bank as its external solicitor in a case that I filed in the High Court for damages for defamation.
Are you on retention?
No, I'm not on retention.
Are you also a solicitor for the Electricity Company of Ghana?
No, I'm not.
Have you ever been a solicitor for the Electricity Company of Ghana?
Yes, I have been before. I've represented them, the ECG, in one matter, which was before the High Court. case has been disposed of. And then also, I was actually hired by an English law firm called Omnia LLP. You know, that was hired by ECG as their lawyers before the London International Arbitration, and I was hired as a Ghanaian law expert, and I appeared before the tribunal on behalf of ECG.
Very well. Was that case in respect of the PDS matter?
Yes, please.
Very well. Leonard, so how was the outcome? What was the outcome of the PDS trial?
Mr. Chairman, let me make it clear. I was lawyer for ECG, that is Electricity Company of Ghana, not PDS. But a dispute was brought by PDS. I want to make it clear. I mean, I know why I'm saying
Chairman, so let's help ourselves with respect. So PDS sued the Electricity Company of Ghana.
That is correct, Mr. Chairman.
Right. So ECG then became a respondent in the matter.
That is so, Mr. Chairman.
Yes. So for the records, you were one of the attorneys for ECG.
That is so, Mr. Chairman.
Very well. So having landed on that point, I shall proceed to ask you, what was the outcome of the said arbitration of which you were counsel for ECG, please?
Mr. Chairman, we are expecting the award in May. Everything that I was supposed to do as counsel has been done, except that my fees are outstanding.
You mean part of your fees? You mean part of your fees is outstanding?
Yes, part of my fees.
Yes. So because you were paid some, and your later invoices are outstanding. That is true.
That is so.
Yes.
Yes, but let me put it on record that I was on the side of the Republic. I want to put this on record that I'm on the side of the Republic. The Republic is the sole shareholder of PDS, of ECG, and I sided with the Republic. I was invited by PDS to be their lawyers. I declined for ethical and political reasons. I want to put that on record.
Chairman, I would want to plead with the nominee that much as it is his desire to provide additional information, I would plead with him to limit himself to my question, because I do not want to prolong matters. If you bring in other matters, then you would lead me into asking. So I want to make it as short as possible. Is that okay?
That is okay, Mr. Chairman.
Now, Honorable Nominee, can you tell this committee the period within which you acted as solicitor for ECG?
You mean in respect of the...
In respect of the arbitration, the PDS
the arbitration has been going on for, Mr. Chairman, the arbitration has been going on for the last, I think, 1.5 years. Yes.
Really?
Yes.
We are in 2025.
That is so.
Is it your case that...
It started way before 2024.
Yes, so that's the clarification I want you to provide. Were you hired in 2018?
Now, in 2018, maybe, Mr. Chairman, he's confusing two matters. There was another matter, that is ASG versus ECG. That is all, that's the short name of the company is ASG, All Services Group. All Services Group and, ECG, okay? So that arbitration was the first time that Omnia LLP requested my services, and then they hired me. And because I performed, to their satisfaction, in the PDS matter, they came back for me.
So when did the PDS sue ECG?
Mr. Chairman, I can't remember off the top of my head, but I can provide the committee with accurate information.
I can give you the opportunity with the leave of chair. I know you did a case with your respected junior, whom you've trained so well. I watched him at the Supreme Court with, with a lot of admiration, and one must compliment him for his great advocacy. He's right behind you, since most times he was holding your brief. Can you, with Mr. Chairman's leave, take the date from him? He's behind you. If Chairman will grant leave.
No, I think the witness is under oath. We cannot allow another person to interfere. So he promised when given the opportunity, he will let you have the date. So we take the witness words.
So, thank you, Chairman. Thank you. So, Leonard, in taking up the case, Electricity Company of Ghana being their counsel, you believed in their case, didn't you?
Very well, Mr. Chairman. I would never take a case. My juniors know that I won't take a case unless I believe in the merits of the case.
And you believe that your client had done nothing untoward in its decisions leading to the termination of its contract with PDS?
Mr. Chairman, the witness really provided the answer that he would never take a case unless he believed in.
And additionally, we are still expecting the award. So I wouldn't be permitted ethically to start discussing the merits of the case.
Chairman, you and I are practitioners, and I will respect those barriers. I'm not going to ask you to narrate to us those details of the case. All I want to ask you is that you believed in the merit of your client's case, to the effect that, in your view, your client had not done anything wrong in the handling of its contract.
That is correct. That is correct, Mr. Chairman.
Thank you.
Hold on, nominee. Honorable member, by the indication from the nominee, the case is pending award. Is that not so? So
that is so, Mr. Chairman.
So it is a matter under determination, and by law, can we be going into the merit of that particular matter, whether you believe or you don't believe in it, since it is pending a judicial determination?
Chairman, I appreciate your intervention. I would humbly plead with you one more time to allow me to flow. I would not cross the barrier, and I believe that you've heard me loud and clear. Now, honorable nominee, and let me say to you that though we have political differences, I respect you for your stance in a lot of matters of national discourse. And without prejudice to any member of the majority caucus or any member of the NDC, you know that you are the only person who has a picture with me, and that picture is in my office. It's there on a purpose. You know that. So I laid that foundation to ask you this other question that is coming up. You took this case with ECG, well aware of the politics of the country at the time, weren't you?
That is so, Mr. Chairman. I operate within the political, legal context of this country, and I'm always aware of the political dynamics, and I consult widely before I do what I do.
So the point I want to make is that you were aware that where you stood in the political space, you were against the tide in taking up the ECG case.
I didn't think of any tide. I thought about the interests of the state of Ghana.
I agree. And that is why I'm celebrating you for that which you did. That politically, the tide was against the government of the day. But here you were, because of your professional stature. And I was happy you made reference to a third-party legal firm that actually spotted you and pulled you out of the lot to be the representation, the attorney for ECG. So that's what the point I want to make, that politically the tide was against you. Would you agree?
I was not conscious of any tide. I wasn't swimming against any tide. I just took a professional decision to agree to serve as counsel in this matter. And the ECG is owned by the Republic, owned by the state. It's a limited liability company with its own board of directors and so on. I didn't think about the political implications of representing ECG, but I knew that the politics around PDS was not, because I also believed in the fact that there was wrongdoing on the part of PDS, and I wouldn't accept a brief, from a company that I believe was in the wrong in respect of a transaction.
So you are saying that ECG is a limited liability company with its own board. So it's a separate corporate entity from the state, though the state is a sole shareholder.
Yes, Solomon versus Solomon.
No. Yeah, I just want to ask that for emphasis.
Yes.
Therefore, the conduct of its board is completely independent from the state, correct?
That is correct.
So if, as Attorney General, you are to advise the states in a situation where the minister, the sector minister, wants to, through a public statement, dissolve the board, would you find that to be appropriate?
Yes. Yes.
Kindly explain.
Yes, Mr. Chairman, because the appointing authority has changed.
Get my statement in question, my question in context, so that you don't have what I'm saying. The question is,
yes,
since you acknowledge through Solomon versus Solomon, they're saying that the body, the company is an independent, institution separate with its own board. I'm asking whether a sector minister will be right in issuing a statement to dissolve a properly constituted board of that entity which you acknowledge as a corporate body with all its rights engraved in law.
Well, we can haggle with the form that it has taken, but that is notionally equivalent to a resolution of the shareholder dissolving the board.
Okay, so let's go a bit into company law, since you are introducing that. So my basic understanding of corporate law is that the shareholders have such rights to take decisions on the appointment of the directors of the firm. And once those directors are appointed, they assume their independence, of course, subject to the articles of incorporation and what the shareholders will so direct. They may have their own vision. Are you saying, therefore, that by virtue of the state being the sole shareholder, without convening an AGM, the sole shareholder, as represented by a sector minister, can sit in an office and issue a public statement to dissolve the board, and that would be sufficient in law? I just want to know from you.
Mr. Chairman, that is why I said we can quibble about the form that this has taken, but a sole shareholder cannot hold a meeting with any other person but itself or himself, right? That's what it is meant by sole shareholder, right? So if I were to advise the minister you're talking about, I would have drawn up the resolution, right, and served it on the members of the board, that by this resolution dated the Tatum Day of January 2025, the board is hereby dissolved. And that would have been very, very appropriate. Okay, so the form that it took is probably what you are quarreling with. Maybe if it is in the form of a letter, without any reference to the shareholders' rights and so on and so forth. That is the, but I mean, that is what you are quarreling about. But as Attorney General, I'll advise that the right thing be done.
Chairman, I think one of the things for which the nominee has earned the respect of many colleagues is his position on the law. And let me say, I appreciate your very candid view on this. And I pray that you will walk the talk and ensuring sanity as we get along, because this, our politics, it is party go, party come. And we need to assure those who take up responsibility in running state institutions. Now, I will proceed to my next observation about you. None of us here can be perfect. There are times that we lose it, and there are times that we get it all well. Have you ever felt frustrated as a lawyer in any matter that you've handled, whether in your private practice or in being a lawyer for the states, in your previous life as a Deputy Attorney General? Was there any point that you felt very frustrated in any brief that you handled?
Well, as professional lawyers, we get frustrated and exasperated on a daily basis. Sometimes it may be coming from the clients. Sometimes it may be coming from the courts or tribunals that we appear before, and so on. Yes, so I have been frustrated before, but that is normal. It's part of, it's part of life.
So,
Mr. Chairman, I don't know what the honorable member is driving at, but if you realize, okay, I don't run public commentaries on cases that are handled. As a matter of, the practice and tradition of my firm, we don't run public commentary unless the matter is political in nature and there's a need for some clarification because of the politics inherent in the matter. But as far as my commercial practice is concerned, yes, sometimes I lose cases, but I don't run commentary on them publicly.
Chairman, please, I claim your attention for the specific language I'm using for my question. My question is, have you ever been disappointed in the outcome of a case, meaning a final judgment in a case you did, whereupon you made some public statement? I'm not talking about running commentaries on a case you do. I am asking whether you recall any public outburst emanating from a judgment in a case that you did.
Mr. Chairman, I cannot recollect. So if yeah, I cannot recollect.
Honorable Dominic Ayini, in the Woyome case, where my Lord Ajet Nasem presided, you, the media, reported you to have said, that is the submission of no case, where the judge ruled in favor of Mr. Woyome. In other words, his application that there was no case to answer was upheld, and your opposition to that application was rejected by the court. The media reported you to have said that the judge had made up his mind even before the case. If that report by the media is correct, on hindsight, do you think that you were right?
Well, Honorable Minority Leader, the witness indicated clearly that he doesn't run commentary. He cannot remember. But you keep on asking about, so the witness will want to answer. Proceed and answer.
Mr. Chairman.
Counsel, hold on a second. Chairman, I've used the word plead with you for the umpteenth time. Chairman, please, stop it. Some of our colleagues are expecting a certain level of conduct from us. I beg of you, let him proceed. Let him proceed, please. Let him proceed.
Mr. Chairman, thank you very much. I think context is very important. Context is very important. I do recall that when the ruling on the submission of no case was granted in favor of Mr. Woyome, I was not directly handling the matter. I was actually supervising the current DPP and a team of lawyers to handle the matter. But then the judge, in his ruling, took a swipe at the Attorney General, that is my boss. He took a swipe at the Attorney General because this was a case between the Republic and Ms. Owoyome. So he took a swipe at the Attorney General. We read the ruling in chambers. We wanted to ignore it, but then lawyers were called who were then running adverse commentary against us in the matter. And so we took a decision in chambers that we needed to respond and to explain. And Mr. Chairman, there's a lot that I know about a judge that you don't know. So don't open a Pandora's box.
Chairman.
Thank you very much.
Chairman. Of course, I recall former U.S. Defense Secretary Donald Rumsfeld come out with this saying that there are known unknowns and there are unknown knowns. I'm sure that is the area you're trying to venture into. However, the unknown knowns which you want to refer to are not a matter that the public became aware of because you did not want to put the unknown knowns out there. That is why you didn't put it out there. I am only interested in the facts that the ones that you decided to put out there. And that is where I seek to ask you a question on. You've explained that it was in context, and I think that's fair enough. I wouldn't belabor. But let's also move to another point. The Supreme Court. There came a time where the Supreme Court made certain pronouncements, which I'm sure you were not too pleased with said pronouncement, and that resulted in some comments by you, and the Supreme Court was not happy, and eventually the gentleman in you, as we all know, you conceded and put matters to a peaceful rest. What have you to say to young practitioners who will be dissatisfied with Superior Court decisions, given your own experience in what happened?
Mr. Chairman, thank you very much for the question. Once I am approved and sworn in, I will be the leader of the bar. And I'll set a very good example. I think even in private practice, you would admit that I am an example. I've never been engaged in any unethical conduct in my practice. So I will lead by example, and that will be from day one. So I wouldn't encourage any young lawyer to, out of frustration, take the judiciary to the cleaners. Because remember that I am not only Attorney General, Principal Legal Advisor to the President, but I'm also the Minister of Justice. I will be the Minister of Justice, meaning that the justice sector will be under my ministry. That will be the principal, apart from the Attorney General's department, to be the principal sector in terms of policy and in terms of law that I will be superintending. And so I would want to have, a very good relationship with the judiciary, a good and respectful relationship with the judiciary.
Chairman, we have become aware of an executive instrument dated the 9th of January 2025. And this executive instrument takes its strength from Section 11.3 of PNDC Law 327. It lists a number of ministries. Conspicuously missing is the Ministry of National Security. Now, in the Securities and Intelligence Act, there is a provision for the creation of the Ministry of National Security. Going in as the Attorney General, would you advise the President to amend this EI to reflect this new enactment that Parliament has passed? Because it appears that His Excellency solely relied on the PNDC Law 327 without paying due attention to the Securities and Intelligence Act, which Parliament passed recently.
Thank you, Mr. Chairman. And I have, previously had to have, discussions on this matter. But in terms of the hierarchy of laws, of course, the Act supersedes the executive instrument. And once the Act provides for a Ministry of National Security, and the principle of law is that Parliament does not speak in vain. We will, take a second look at it and then advise the President accordingly.
Thank you very much.
Honorable colleague.
And you have a long way to go, Honorable Leader.
Chairman, kindly stop this act.
I'm just asking.
Chairman, kindly stop this act.
Because you seems to be taking the whole day.
Chairman, kindly stop this act.
Well, honorable members, I think there should be a ceiling on a number of questions that the leadership is also supposed to ask, so that we don't go to town, we go straight to the point. So at our meeting, we need to take a decision as to the number of questions that leaders are entitled to ask.
Chairman, indulge me. Chairman, indulge me. Chairman. He's not even listening. Chairman, recognize me. Recognize me. Recognize me. Chairman. Listen to you.
Let him go. Huh? Give you the opportunity.
We should allow a free flow of proceedings. Okay? I beg of you. Honorable nominee,
I feel it's been abused.
In Article 181(5) of the Constitution, that provision in the Constitution received some judicial pronouncement. The very first one, I believe, the Clomega case, Clomega versus Ghana Port and Harbors, where the Supreme Court had an opportunity to make some pronouncement. I believe that the court made some consequential orders to the effect that Parliament would have to ensure certainty in that provision of the Constitution by enacting a law to regulate 1815. It's been long overdue. We don't have a law yet. In the Sebe Yabwa case, the Supreme Court even distinguished the law further, made a clear path, and said that even in situations where the transactions involve state entities with its own board, it wouldn't be considered as part of 1815. However, they still felt that Parliament has failed in enacting a law to regulate 1815. Now you have the opportunity. Can you assure the country that
he has the opportunity, or is going to have the opportunity? Or if he gets the opportunity?
Yeah.
Chairman, I think this question on Article 181,
your leader is speaking.
I sought leave from the chairman.
And what about?
I sought leave.
In relation to what I am saying, that now you have the opportunity, or now you are going to have the opportunity?
Bringing a very important matter to your
is it on that issue?
I'm bringing a very important matter to your attention. That the Speaker set up a committee on Article 181.5. And that report and bill is ready. That's for your information.
Thank you very much. So, Leader,
and Mr. Chairman,
your wedding, now you have the opportunity. Do you still stand by it?
Mr. Chairman,
now that he's going to be given the opportunity?
Yeah, just to add to what the Honorable Patrick Boama has said.
Honorable nominee, hold on a second. Let me handle the matter with the chairman. Chairman, let me flow, okay?
You have been flowing on and on. On and on.
Let me finish.
Your statement is as if he has been approved.
Chairman.
Now the Attorney General. Meanwhile,
Chairman,
we are in the vetting process.
I'll go back to the question. Honorable nominee, now you have an opportunity back to the Attorney General's chambers. Will you assure us that steps will be taken to enact a law to regulate 1815?
Thank you, Mr. Chairman. Just to add to what the Honorable Patrick Boama has said in answer to your question, Mr. Speaker set up a committee. On the side of the then minority, I was a member with the Honorable Dr. Kaisel Atuforsen, and then the Honorable Elizabeth Ofosajari. And we came up with a bill. I'm a co-author of that bill with the Honorable Joe Gatti. And the bill was supposed to be laid in Parliament before we rose. But because of certain developments that took place, the bill has not been laid. I'm very satisfied being an author of the bill. We took, part, the Honorable Patrick Boama and I took part. We even had a stakeholder consultation, and the bill is ready. So it was Parliament's bill and was being sponsored by the members of Parliament from both sides. If Mr. Speaker still has that intent, I will allow that process to flow to its logical conclusion. Otherwise, I will adopt it as Attorney General, and with the backing of the Minister of Finance, Dr. Atuforsen, we'll bring the bill back to Parliament, and then it will start the process of first reading through to passage. So that is what I can assure the country.
Very well. So, Honorable nominee, you have become aware of the aura.
Yes, Mr. Chairman.
In your view?
Oral was an integral part of our campaign message.
Right.
And our campaign, I was a surrogate campaigner for His Excellency John Dramani Mahama, and he's committed to oral, and I'm committed to it as well.
Right. So, good. In your view, do you see this committee as a constitutionally empowered committee? You think that it has a constitutional backing or any statutory backing to have this committee in place?
Well, if by constitutional backing, there are two ways by which the Constitution would have backed oral. That is, if it was specifically stated in the Constitution, such as the Commission on Human Rights and Administrative Justice, which is not the case, or if the Constitution provided the framework, the constitutional framework for the establishment of a body called the Operation Recover All Loot. But I think I stated quite, clearly, and I don't know whether you were in the room when I gave the answer, that one of the fundamental principles of the Constitution is the principle of accountability. And oral is about exacting accountability. And I think that my colleague, senior colleague, and partner, the Honorable Mahama Yarga, added substantive, sense to what I did, the answer I gave, by making a reference to Article 41F of the Constitution, and the obligation on all citizens, to take steps, to protect public property and to avoid waste of public, funds. So I think that oral is not unconstitutional. Oral is not illegal. Just because it was not set up by an act of parliament does not necessarily make it an illegal body. So it has constitutional backing in terms of the fundamental values of the Constitution.
Chairman.
Well, before you come in, I recognize Roxanne Dapamopo on point of information.
Chairman, thank you very much. Chairman, the minority leader in submitting just a minute or two ago in respect of the Act 1030. Act 1030 does not provide for the establishment of national security. It provides for the functions of the minister. That's what it provides. And so there are two markedly different issues.
Thank you very much for the information. Honorable
Chairman, respected colleague, to get the law, open the provision that he is relying on, upon which he disagrees with me. He should open the provision, because the Act provides for certain ministries and provides for minister responsible for national security, minister responsible for finance and all. If he's saying that there's no such provision. No, please. Yes. Honorable.
So Chairman, Honorable member, I recognize Honorable Ayariga to read the Act.
Chairman.
I recognize Honorable Ayariga to read the Act.
Chairman.
Honorable Minority Leader, few minutes ago you said that he should read the Act. And Honorable Ayariga quickly wants to read the provision. So why are you not
Chairman.
comfortable with the Act being read? Honorable Ayariga, go ahead and read that.
Mr. Chairman, the Act severally makes reference to a minister. And then it goes to the definition section, and then it says minister means the minister responsible for national security. So it could be any minister of the president that he has assigned responsibility for national security. It doesn't command the establishment or continuing existence of a Ministry of National Security. Even when the provision tries to define a ministry, assuming that a ministry is mentioned, it adds and says that ministry means ministry responsible for national security. It doesn't say Ministry of National Security, but the ministry that is responsible. So the president can assign responsibility for national security to the Interior Ministry, the Defense Ministry, or indeed the Ministry of Upper East. So that is the president's prerogative.
Thank you very much. I think this is a usual rendition in our laws that would define ministry or a minister to mean minister responsible. So if today the minister responsible for roads should be the minister responsible for transport, the designation will be made as such. So I do not think this is an issue that we should belabor. Yes. I mean, it is clear now. So, leader, proceed.
Chairman, with the greatest respect, you are expressing an opinion. Don't say it is clear now. The interpretation column of Act 1030 provides for the definition of minister. I've been part of legislation, at least for the past 12 years. It provides minister means, it didn't say include. Minister means the minister responsible for national security. Then it goes on to say ministry means ministry responsible for national security. In all humility and at the risk of sounding immodest, the argument that it could be any ministry by the president, to say the least. Anyway, again, if you go to section 11, section 11 provides Ministerial Security Coordinating Committee, and it provides, without limiting section 10, there shall be the Ministerial Security Coordinating Committee, which consists of the A, Minister responsible for national security, Minister responsible for foreign affairs, Minister responsible for defense, Minister responsible for the interior, Minister responsible for finance, Minister responsible for communication, and Attorney General. So the law is very clear, and it is not a matter of the president assigning interior minister to be responsible for national security. It is provided for that we would have a minister of interior, a minister of defense, a minister of national security is there. Mr. Chair.
Honourable members, you see, at a point, the rendition changed to minister responsible, not minister of, because of these issues of realignment. So if today a minister responsible for Greek is supposed to be in charge of the national security, he is the minister responsible for national security. That is the designation. That is the reason for changing the rendition. We could say simplicity the minister for national security, but we are saying minister responsible for national security. We've taken into consideration issues of realignment of this nature. That is why Because other than that, each time there is a change, you must come and amend the substantive law in consonance with the change that you have made. But once you say minister responsible, it is incumbent upon the president to dedicate that to a minister appointed by law. So all the laws from 2020. I believe this is even a Cavendish drafting, of which I am part.
May I ask, whilst nobody intends to hold the hands of the minority leader, but we cannot also say that the space provided for the minority leader means that, I remember I sat here beside Honorable Ato Forson. Honorable, the former chair would always insist, how many questions do you have? Honorable Ato Forson will have to declare, I have this number of questions. Is it the case that the only way to satisfy the minority leader is to say that as long as he's got questions, he must continue, even if it's tomorrow, to be able to say that that is the only one? Chairman, I would suggest, at this point, Chairman, at this point, then the minority leader had enough time to make his point. So I think you should be beginning to give an indication as to how far this is going to go.
Honorable Chief Whip, I'll be magnanimous to ask him to ask 3 questions. Then we can bring proceedings to an end. So you may ask the first one.
Honorable nominee, if I heard you correct, if I heard you right, it is your case that the establishment of the ORA committee is legal.
Yes, Mr. Chairman, it is.
Now, you are aware.
Second question.
You are honorable chair. If you have been very calm managing, if there is an attempt to disrespect me and to create a problem, Chairman, stop.
Far from that.
Chairman,
you are putting words into my mouth. I am not in any case
I have been very quiet and very
but
calm.
I think
Chairman,
you are trying to be very abusive.
Chairman, stop it.
I'm not disrespecting you in any manner whatsoever.
Chairman, please.
I am not in any manner disrespecting you. We've accorded you all the opportunities in this world. We have accommodated you.
Chairman, excuse me.
Chairman, so how do you say I'm disrespecting you?
Can I respectfully go to outstanding orders? Order 2 and 7.
Honorable Boy, you have the floor.
Chairman, been very patient. But Chairman, we in Parliament are guided by outstanding orders. Order 2171 on the appointment committee. The appointment committee comprises the first deputy speaker as chairperson, the minority leader as ranking, and the deputy majority leader as vice chairman, the deputy minority leader as deputy ranking member, and then he lists the following. There's only one chairman. Only one chairman. We don't have co-chair of this committee. And the rules of this house is that we allow the chairman to lead us and direct everybody so that we can have an orderly business. My respected Honorable Afenyo Marcus has chaired committees, and we've always deferred to him that allow all of us to basically do the work. It is as if he is not respecting the chair. And it is completely not right, especially on an appointment committee where the whole public is looking at us. I think that where we are, the right honorable, my colleague, please, let's respect the chair. He will give you all the opportunity. But when the chair makes a determination, you will be the first to support him.
Honourable Member, your second question.
Chairman, with respect, I beg you. We've come very far with the nominee, and I think we don't want to end this day having vetted the finance minister designate, the energy minister designate, and our respected colleague in this kind of situation. I beg of you, Chairman, we've come very far. Please, let's give him the space to finish. He has guests from his constituency, chiefs. We don't want him to leave this room disappointed. We've come very far with him. Let's indulge the minority leader to end his question, please. I beg you. I know why I'm saying that.
Can't he just give us
I beg you.
Have 20 more?
I beg you. Let's give Kwame. We've come
So we
very
need
far.
to be guided. Minority leader,
We've come
how many
very
more
far.
questions do you have?
They're asking him questions, they are taking the mic.
I need some answer from him so that we can be guided regarding the number of questions that he has to ask. No, we cannot finish tomorrow. Well, he can say that we'll finish tomorrow. The whole world is watching us.
Yes, Honorable Chair, please. I think we've been on this committee, and we've had a case where Honorable Haruna Idrisu have been vetting and questioning until he's satisfied with it. Yes, even sometimes he starts with a warm-up and he goes, but please, I think where we are at the moment, let's try and indulge him and then finish up with him. I'm sure he's almost at with the end of his interrogation.
So we just need an indication from him. How many more questions does he have? Or how many more minutes does he want to be given so that he can finish up his question? Leader, how many more minutes do you want? Or how many more questions?
I think if you leave him, he will be able to wrap up. He's here. We are all here waiting.
So, leader, you have the opportunity to wrap up using the words of the deputy leader.
No, I said, you just leave him. Allow him
to wrap up.
Through the questions that you want.
No, the word I've heard is that he should wrap up.
What
so
is happening here?
You have the opportunity to wrap up.
On the other side, nobody asked any questions. And he needs to also satisfy himself and make sure that the questions that were not asked are being asked at this point in time. That's how I feel it. Once you didn't ask questions, you can ask questions to that effect.
Chairman, thank you very much. Honorable nominee, you are aware as a legislator that when the former president, His Excellency Nana Addo Dankwa Akufo-Addo, in his fight against corruption, decided to set up an independent body, he had to come to Parliament to enact that law for the purposes of the office of the Special Prosecutor. You are aware of that?
Yes, I am, and I was, a key actor during the enactment of the OSP because of where I came from.
You were also a key advocate for the law to be enacted to enable the Office of Special Prosecutor have the legal powers to proceed with its work, correct?
I don't know what you mean by a key advocate. I took part in the lawmaking process. Go back to the Hansard. My initial position was that it was an unconstitutional body because it was, to me, violative of Article 88 of the Constitution, because we're taking the constitutional powers of the Attorney General and giving it to another person and seeking to say that Attorney General that person should be autonomous or independent of the Attorney General. And I said, no, those prosecutorial powers inherently belong to the Attorney General, and no one can take them away and then say that the person should be, ring-fenced in such a way that that person, should not be controlled by the Attorney General. I made very forceful arguments to that effect, and that is how come that there were provisions, the independence provisions were watered down at my behest. And of course, I was just a lone ranger at the time, but I'm no longer a lone ranger. I'll take a look at the law again.
So now, in view of that reasoning, what you hold so firm, and if I may have to repeat, you're saying that the establishment of the Office of the Special Prosecutor took away the prosecutorial powers of the Attorney General. Now we have ORA with investigative powers. Don't you think, in line with the same reasoning, that committee is taking away the investigative powers of IOCO and the police?
I am not aware that.
Honorable nominee, before you come in, you made reference to Article 88, particularly Article 88.3, that gives exclusive jurisdiction or power to the Attorney General to conduct criminal cases. And any other body that is conducting a criminal case is doing so on the authority of the Attorney General. Therefore, I recall that in the passage of the Special Prosecution Act, argument was canvassed to the effect that we cannot give the Special Prosecutor, by an act of Parliament, power to do prosecution. And this was heated to the extent that the Attorney General at that time agreed with our position. They used their numbers 169 against 106 to push the law, and when it gets to the third reading, the Attorney General then declined to come and move the motion for the third reading, leading to the passage of the law. But today, it's being stated that there was argument from the nominee to the effect that special prosecutors will have power to prosecute. The Constitution is very clear on power to prosecute, but not power to investigate.
Honorable nominee, my question to you is this. Here is a committee without any legal backing, of which you say and insist that it is legal. I'm asking you, this committee is out there saying it is investigating supposed looting. Now, we have state institutions with the mandate to investigate allegations of corruption, conflict of interest, and certain actions of public officials. Shraj is a typical example. We've had situations where members of the public have gone to Shraj on certain matters. We have the police. The police has various units that does investigations. We have IOCO. We established IOCO, Act 804. If you look at their mandate, they have all the powers. Are you saying that this committee does not conflict the work of these statutorily established state agencies?
Mr. Chairman, no.
Your answer.
No, it doesn't. And I'm not aware that Oral has been, conferred with investigative powers. They are gathering information for purposes of determining, whether or not some wrongdoing has taken place by a higher body. I remember them saying that once the Attorney General takes office, they will hand over the information. It's like a whistleblower, coming to the Attorney General with information. There's nothing legally wrong with that. So I still stand by that.
Thank you very much. I don't know why Oral is posing so much threat to some Ghanaians.
There's somebody stopping NIB board from stealing land here.
Honorable nominee,
What is lawless about?
if I understood you correctly, is it your suggestion that upon taking office, ORA shall cease to be in operations? I just want clarity.
Honorable Leader, the nominee never said so. So I do not know the clarity that you are seeking from something that the nominee has never said.
Okay, no problem. Honorable nominee, since Chair says you never said so, let me now ask you.
And I did not say so.
That's okay, no problem. That's all right. Honorable nominee, are you saying that because you believe that ORA has a legal backing, your office is going to continuously depend on ORA for the purposes of providing you with information for your prosecution?
Honorable Minority Leader, the nominee never said so. So you may ask another question.
Chairman, please, for the third time. Honorable nominee, as Attorney General and Minister of Justice, you will primarily rely on state agencies such as police, IOCO, and FIC for the purposes of building your case for prosecution, correct?
Well, the qualification primarily doesn't sit down well with me. Some of the institutions we've mentioned have statutory power to conduct investigations that are restricted. So, for instance, if you take, IOCO, economic and organized crime, period, they can investigate anything relating to, say, murder or treason and so on, or other crimes. All right, so their mandate, their investigative mandate is restricted to economic and organized crime. So they are creatures of statute, okay? The Attorney General will rely on any source of information, okay, that will lead to the detection of criminal offenses, whether relating to corruption, whether relating to looting of state property, and so on. Once that, gives us the basis to gather evidence of wrongdoing, we'll aggressively pursue it and then it will serve as the basis of prosecution.
Thank you once again. Listening in silence.
Chairman,
do you have any more questions?
Honorable nominee, thank you for the response to my earlier answered question. Now, you have indicated that the mandate of ORA is to gather information for the Attorney General. So, I want to ask you, as Attorney General and Minister of Justice, will you continue to depend on ORA within the period of your service to the states as Attorney General? I want to know from you.
Mr. Chairman, I think I have made it abundantly clear that I will depend on any reliable source of information relating to wrongdoing that will mandate that we investigate. And by the way, one of the new things, Mr. Chairman, one of the new things that I will be bringing to that department is setting up an in-house investigative unit.
Thank you very much. I recognize a supplementary question from the Chief Whip, Honorable Kwame Governor Sakboja.
Honorable Dr. Ayeni, will you say, or will you agree with me, that oral is in line with Article 41F, which says, the preamble says, the exercise and enjoyment of rights and freedoms is inseparable from the performance of duties and obligations, and accordingly, it shall be the duty of every citizen, in fact, not even oral alone. F, to protect and preserve public property and expose and combat misuse and waste of public funds and property. In this case, I cite an example of what ORA put out, that an individual of this country was trying to take over land that doesn't belong to him. The individual came out through his lawyer to say it is not true. Yet ORA put out details from lands registry showing that that individual was almost illegally or taking over land that doesn't belong to him or at a price that is not fit to be sold at that price. In your case, do you think ORA has done this country good for that exercise, which is not illegal? Nobody was beaten, nothing was done to anybody, just that that piece of land has been saved for this country. Will you say that ORA has done well as far as you are concerned?
Nominee, please answer the question.
Mr. Chairman, the honorable member has described aptly how citizens comply with Article 41F of the Constitution. Thank you.
Honorable Minority Leader.
Thank you, Chairman. Good intervention by my respected colleague, Kwame Akboja. A good constitutional exercise we are doing now. So, on the Article 41 that he has introduced, the 41F, Chairman, I would want to know from the nominee that upon reading of Article 41F, which was relied on by my respected colleague, would you say that the exercise of said duties is not done in accordance with law? Because he created the impression that it means that any citizen can get up in the name of protecting public property, go to an institution and start warning public servants, locking up offices. As we are experiencing, people are being chased out of their homes, people are being beaten. and he is on public television quoting the law and saying that Article 41F, and I'm reading it. He said to protect and preserve public property and expose and combat misuse and waste. Now, we are hearing and seeing on our TVs what is happening at public institutions. People are being chased. In their homes. Is this the interpretation given to the 41F or side duties? Provided for in this particular provision is supposed to be exercised. Within the confines of the law.
Honorable nominee, before you come in to answer the question, you can profile your understanding of Article 41F of the Constitution of the Republic of Ghana. But there is no evidence before us that Oral has gone to lock people's offices, they've locked people's houses, or they've beaten people up. So I would even urge the Hansard Department to expunge that aspect of the question so that you can go ahead and tell us your understanding about Article 41F of the Constitution of the Republic of Ghana.
Chairman, with respect, nominee, Chairman, with respect, this particular question, I did not refer to ORA. Please, I did not refer to ORA. I did not anchor it on ORA. If I can repeat it, I did not.
Well, if your reference is not to oral, then we do not have evidence before us that such a thing has happened. And that is the more reason why that should be expunged from our record so that the nominee will go ahead and then give us his knowledge about Article 41F of the 1992 Constitution of the Republic of Ghana, with due respect to my learned friend.
Okay, so then let me, just because for the purpose of clarity, let me now rephrase the question so that the nominee will not be in any form of confusion.
So that question is expunged.
That's okay.
You may go ahead and ask another
that's okay.
question.
That's okay. Honorable nominee, have you become aware of post-election violence by some Ghanaians? Have you become aware?
Honorable nominee, are you aware?
I'm not aware of any violence.
Very well. That's okay.
Yes.
That's okay. That's fair enough. Honorable nominee, have you become aware that some Ghanaian citizens have been going into public offices, locking up public offices? I would want to give you an example. Ghana Port and Harbour Authority.
Well, Honorable Minority Leader, is that not part of the violence that you refer to, that the nominee said he is not aware?
Chairman, I've been reminded over and over again that you are the chair. Please. I asked the first question of violence. He said he's not aware. That is fair enough. My second question is, has he become aware that some Ghanaian citizens have been marching up to certain public offices, locking up the offices, and I'll give you the examples. Ghana Ports,
meaning they
CDC,
are peacefully locking those places, or is part of the violence that you are talking about?
There were people looting rice from a warehouse.
Chairman.
People are going to lock it. How is that violence? Violence against the rights?
Chairman, can I proceed with my question?
Yes, proceed.
At TDC, locking up the offices. At Bui, locking up offices. Have you become aware of these actions?
Well, nominee, are you aware?
Chairman,
Has it come to your attention?
it hasn't come to my attention. That is true. On social media, I see reports, but I haven't read them.
Thank you very much. Any further question?
Mr. Chairman, to the nominee, should you become aware of the conduct of some of our citizens, the conduct of going to state institutions, threatening public servants and civil servants, locking their offices? Should you become aware as Attorney General, what would be your reaction by way of advice to the government?
To be honest with you, I would not want to comment on this because it will prejudge whatever steps I will be taking or may be taking in order to address the situation. Until I have the full complement of facts, I will not be able to proffer an opinion.
Thank you very much. But let me remind the entire nation that 2017, such a thing was complained about, and then chairman was heard saying that if people are protecting public property, what is wrong with it? MPP chairman, Freddie Blay, is on record. See? I can produce the record for you.
Chairman,
recently it was circulating.
Chairman, a moment ago, when I was asking a question, you asked me that since there's no evidence before us, you directed that that question should even be expunged. That was the position you took. I have asked a straight question. You are now introducing Freddie Blay, who is not here to defend himself and to say this and that. Chairman, in all humility, I believe that since you are calling on the Ghanaian public to watch proceedings, consistently since morning, there are members of the public behind each of the nominees who have gained notoriety for shouting and heckling as if they are part of the proceedings. You have had the cause to ask them to stop. They continue to do that. You see, let's be fair, because if something even happened yesterday, are we saying that we should continue to endorse it? I beg of you, we are a nation making progress in our governance at all levels. I would want to plead with you that withdraw or retract the mention of Honorable Freddie Blake's name. If you think that you want to... Can I finish, Chairman, let me finish. You are the chair. You will have all the powers. I beg you, let me finish. I think that it is most unfair to Honorable Freddie Blake, who is resting at home, to be mentioned here when there's no matter relating to him. I would humbly implore you to take his name out of this matter. If you think you still want to keep his name in, that is up to you.
Honorable Minority Leader, people are asking of the evidence. My source of the information is Star FM headline. I would therefore urge upon Honorable Ayariga to read it for the entire nation. And if you still want me to withdraw, after giving you the source of the information, then I will listen to you. Honorable Ayariga.
Star FM published this January 12, 2017. MPP members only protecting state facilities. Blake justifies takes over. And then it says the acting chairman of the New Patriotic Party, Freddie Blake, has defended the lawless and violent seizures and takeover of state facilities by some members of the party. According to Mr. Blake, not all the takeovers of state facility by MPP members must be condemned, since in some cases the supporters are only protecting government agencies. Should I continue? I can stop there.
Honorable Member, thank you very much.
Chairman.
Okay, I recognize Honorable.
Yes, Chairman, not too long ago, the respected leader referred to some of our citizens sitting behind the nominee as foot soldiers who were brought here to make noise. I take an objection to that. Foot soldiers brought myself and the minority leader here. So their presence at vettings cannot be a nuisance. Secondly, he suggested that they have gained notoriety for making noise. I have been on this committee. Indeed, sometimes when nominees give answers, it generates spontaneous reaction from the back. They are not notorious. So may I also ask my respected colleague to probably rephrase the rendition that says that foot soldiers were brought here to misbehave, and also they have gained notoriety for doing something that they've been warned not to do. It is his choice to either oblige and do that, or decide that foot soldiers are not to be seen in Parliament. If that is what it means, I wouldn't mind my foot soldiers to be here, because they are the ones who brought me here. So it's up to you.
Thank you very much. Once again, as a chairman of the committee, I will apologize to our dear guests for any comment in any manner whatsoever. So I sincerely apologize. Honorable Minority Leader.
Thank you, Chairman.
Are you done?
Yeah, Chairman. I have my last set of questions for my respected colleague. That has to do with nomination to the Supreme Court of Ghana. Leonard, we, unfortunately, as a House, could not take the appointment committee report on 2 nominees of His Excellency the President. One, Professor Richard Frimpong-Opong, 2, Justice Sophia Rosetta Odukua Benasco Issa. I know that whatever was pending before the 8th Parliament is not binding on the 9th Parliament. In any event, there is even a new president. Now, what is your own view regarding these 2 citizens of the land? The ordeal they've gone through and the fact that Parliament could not elevate them. Given the opportunity as an Attorney General to make an input in any nomination, any future nomination to the Supreme Court, would you consider making your views known on these 2 nominees to the appointing authority?
Honorable Minority Leader, you rightly stated the position that nomination during the tenure of office of the 8th Parliament lapsed by the 8th Parliament. And in the 9th Parliament, we have another executive president in whom the power to appoint is vested. The nominee before us doesn't have the power to appoint. And there is no law that states that he should make an input into the appointment of the Supreme Court judges. So I believe strongly, with all due respect to you, this is not a fair question to the nominee.
Chairman, please kindly allow the context of the question to proceed. I ask the nominee, in view of what happened, these are citizens of our country who were nominated, who went through the rigorous vetting of this committee. Now, there is a new government. There's a new parliament. I want to know from you, what would be your advice to Mr. President, if you have the opportunity, on these 2 individuals in any future nominations by His Excellency the President?
Thank you very much, Honorable Minority Leader. You know, the nominee is designated for the position of Attorney General and Minister of Justice. He is supposed to advise the President on all civil and criminal matters. Legal matters, for that matter, must be by the advice of the Attorney General. But it is different from issues relating to appointment. And here we are asking the nominee his view, his opinion on some judges that were appointed by the previous government, which couldn't get through and the appointment lapsed. So let's allow the executive president to exercise the power vested in him by Article 58 of the Constitution of the Republic of Ghana. Thank you very much.
Very well. Honorable nominee, please, do you know Professor Richard Frimpong-Opong? Do you know him?
Thank you very much, Mr. Chairman. Professor Frimpong Opong, just like my former students line up here all the way to Roxin Dafiamapo, is a former student of mine. I taught him at the then Faculty of Law, University of Ghana, and I know him very well, just like the same way I know Roxin Dafiamapo as my former student.
How do you know his practice of the law?
Are we dealing with...
Mr. Chairman, I have no details of his practice of the law.
Very well. The question has been answered.
Should you...
No details of my practice.
Should you be given an opportunity to recommend him for nomination to the Supreme Court of Ghana, will you willingly proceed to do that, knowing his record, his academic record, and his exploit in his chosen career?
Let's cross the bridge when we get there.
Do you know his academic record?
Yes, I do, because I taught him, I graded his papers. You know, he was a first-class student. Actually, the two first-class students were himself and then the current OSP. So I know him very well. But I'm not ready to opine on whether or not I recommend him to President Mahama for appointment. That the prerogative of appointment is that of the President, not mine, as Attorney General.
Thank you.
So that is true. And you are not the one to do nominations. But my question is, in view of the fact that you know his academic records and you know his professional career, if you are given an opportunity to recommend him for nomination to the Supreme Court, would you be able to make that recommendation?
Thank you very much. The nominee has provided an answer that appointment is an exclusive preserve of the president, not his. I wonder if you have the opportunity, or he has the opportunity in law to be recommended.
Okay, Chairman, with respect, Chairman, with respect, if you pay attention to me, we will be done.
It's just suggesting that I wasn't paying attention to you.
Chairman, can I ask?
Are you suggesting I'm not paying attention to you?
Chairman, can I ask this question so that we can do what we're supposed to do?
Chairman, is disrespecting you.
Chairman, can I ask the question?
Chairman, I'm not being disrespectful. I think the whole world knows we have done enough by giving opportunity to the minority leader. Chairman, I will request you close the meeting now. We have done enough. No one in this country will say that we haven't given enough opportunity to the minority leader. Enough is enough. Enough is enough, the chairman. Nobody will say he's not been given opportunity. It's enough.
Chairman, thank you very much. Chairman, my question is not about the nominee appointing a Supreme Court judge.
We say we are tired of you.
My question is not about the nominee appointing. I asked the question that the honorable nominee, in view of the fact that you've said on record that you know the academic pursuits of the Professor Opong, and you know his professional exploit.
Mr. Chairman, I never said I knew his professional exploit. I said I taught him, I know his academic record. And on the record, it is not only academic qualifications that presidents take into account in appointing, judges. So, and I'm not the appointing authority. I'm not going to sit here and opine as to whether or not, if I were hypothetically the appointing authority, I would have appointed him to the Supreme Court. And when you asked me the question, I said, if the president asked me, his opinion, let's cross the bridge when we get there, because there will be a number of variables that the president would have taken into account in requesting my opinion. So I don't think that it is fair to me to want me to be answering hypothetical questions about future appointments.
Okay, my final question to you.
All members, let's allow. Let's take him by his words. Final question.
Honorable nominee, you are now going to practice before our court as the first gentleman of the bar. Do you have confidence in the justice delivery infrastructure of our country?
Yes. Mr. Chairman, I do have confidence, but there's room for improvement. It is not perfect.
Thank you very much.
Chairman, I would want to thank you. Chairman, I would want to thank you and thank the nominee for taking time to answer all necessary questions. I wish you well and pray that you are able to discharge your duties as Attorney General and Minister of Justice for the good of our country. And again, I pray that the opportunity given you to serve as Attorney General will be another opportunity for you, with all your years of experience in academia, in Parliament, and in private practice, to enrich rule of law. Thank you very much indeed, and God bless you.
Thank you, Mr. Chairman.
Thank you very much, Minority Leader and members. Honourable members, before discharging the nominee, let me bring it to the floor that the actual communication to Parliament signed by His Excellency, the President of the Republic of Ghana, His Excellency John Dramani Mahama, to the Speaker of Parliament has come to our notice. So all along, we were relying on a document that has been corrected, and the correct version has been brought to our notice, and the Minority Leader has perused same, and I believe he is satisfied with the content. You know, he indicated that he wants the right thing to be done at the time that we have no knowledge that it has already been done. So I believe he's seen a copy of it, that we have now seen the correct document. Honourable members, may I use the opportunity to congratulate the nominee and thank him sincerely for attending upon the committee, and to say that you will hear from the committee. You are accordingly discharged.
Thank you, Mr. Chairman.
Honourable members, only the members should stay. Members of the committee, not friends, should stay.
Chairman, let me just acknowledge. Honourable nominee. Oh. Honourable nominee. Oh. Honourable nominee.
Honorable nominee, you are discharged. Vetting for today is over.